Welcome to the webinar on seclusion and restraint. My name is Michelle Murphy, and I work with the Utah Parent Center as one of the associate directors. I'm so glad that you guys are all here and able to join us this afternoon. We are in store for a really special treat today, but before we begin, I just want to tell you a little bit about the Utah Parent Center. Hopefully most of you guys are familiar with what we do, but we are a resource, information, and referral center. We're available to help parents throughout the state of Utah and help provide you with information, referrals, and support to help you help your children live productive lives as members in the community. You're welcome to call our main office anytime at 801-272-1051, or you can go to our website, which is www.utahparentcenter.org. We've got lots of helpful resources that you can look at and access from our website as well. We're really excited to present to you this Lunch and Learn series. This is something that we're going to be doing monthly, and it's part of our IOTI grant that's offered through Utah State, so we're really excited to do this. Each month we're going to be offering a different webinar that focuses on a topic surrounding behavior or transition supports for youth ages 14 years and older. So this is our very first one, so we hope that you'll join us for some of our future ones as well. This session will be recorded, so you will be able to access this at a further date if you're unable to join us today on our website, so please keep that in mind. So feel free to tell your friends and other people that might be interested that they can access this at a further date as well. Everybody will be on mute right now. If you have a question or a comment and you would like to share that, go ahead and type it in the chat box as we go along. There will be time at the end of the session for questions, and we will be checking that chat box to see what questions you might have. But you will be on mute right now throughout the duration of the webinar so that we can have a good listening experience for everybody that's participating. And I think that's about it. It looks like we have one question. Did you say this webinar is for 14 years or older? The answer to that question is no. This webinar is for all ages. However, in the future, we may be having some webinars specific to certain age groups. However, this webinar is for all ages. So with that, I'd like to present our presenter for this month's webinar. Her name is LauraLee oh my gosh,
Gillespie.
And she is from the Disability Law Center. And she's going to be talking to us about seclusion and restraint, what parents need to know. This is a really important webinar and a very important topic for parents and professionals to understand. Seclusion and restraint has been a really hot button topic, both nationally and here in Utah. It's something that's really important for parents to understand, especially if you have a child that has behavioral concerns in the school system. So I'm really excited to hear her presentation today. You guys are really going to enjoy it. So what I'm going to do is turn on the screen sharing function so we can see her presentation, and then we'll turn the time over to her. As I said before, feel free to type in your comments into the chat box, and we will address those at the conclusion of the presentation. Thank you so much for joining us, and we will get ready to turn the time over to her. Okay, LauraLee.
Hi, so first of all, just to tell you a little bit about myself, my name's LauraLee Gillespie. I am an attorney at the Disability Law Center. I was a former educator. I taught first grade for about 8 years before going to law school and coming back to do work in the area of special education law and people with disabilities generally at the Disability Law Center. The Disability Law Center is the protection advocacy unit for the state of Utah. So we are funded by federal grants and private donations, and our role is to help protect and advocate for the rights of people with disabilities. I am an attorney. However, I am not providing legal advice in this presentation. My role is to help you to understand the law as it's currently written regarding restraint and seclusion, and let you know what resources are available. If you do have further questions, as Michelle said, we'll be happy to answer at the end, or you're welcome to contact me at the Disability Law Center. Okay, so restraint and seclusion is what we're going to talk about today and what parents need to know. Now, I want to start out by just explaining what we mean when we say restraint and seclusion, because it can mean different things in different places, and frankly, the law can make it more confusing than it needs to be. So I want you to have a good understanding of what it is, and then we're going to go through a little bit of history in terms of where we've been going over the last 10 years. We're not going to spend too much time on either of those things. And then I just like to explain to you what the legal obligations are at this point in terms of the laws and what you should expect for your students in school settings. So when we talk about restraint in this presentation, we're talking specifically about physical restraint. And the reason I make that clear is because there's other types of restraint, like mechanical restraint, where students are put in chairs for posturing purposes, or chemical restraint when somebody's given some sort of medication or something to control. That's not what we're talking about today. What we're talking about is physical restraint. And the way that the state law, as well as the regulations from the Utah State Board of Education, define it, and I'm just going to read this, is a personal restriction that immobilizes or reduces the ability of an individual to move the individual's arms, legs, body, or head freely. We're not talking about what's known as a physical escort. That's when we temporarily touch or hold someone's hands, arms, wrists, or shoulders, or back for the purpose of guiding them somewhere. I want to be very clear about that, because the law delineates between the two, because sometimes that's needed and other times it's not. Okay. In terms of seclusion, again, we want to be clear what we're talking about here today, and that's about seclusionary time out. There is no actual state law specifically that outlines seclusion. There is state board rule. The Utah State Board of Education has created rule based on discipline of state law to prevent inappropriate seclusion. So when we're talking about seclusionary timeout, we're talking about a student being placed in a safe and enclosed area, being isolated from adults and peers, and being prevented from leaving or reasonably believing that they are prevented from leaving. We're talking about, essentially, it could be any room. Sometimes we're talking about a padded booth. Other times we're talking about maybe it's a little study room off the side of the library. The key is that it's a safe enclosed area. It's for isolation from adults and peers, and they can't leave or they don't believe they can leave. So what's the history? Well, about 10 years ago, a couple of studies came through that were really high on looking at restraint and seclusion in schools. One was by a woman named Jessica Butler, and it's called How Safe is the Schoolhouse? She was essentially looking at the laws across states regarding restraint and seclusion in schools. And what she found in the beginning was quite staggering. There were many states with nothing on the books in regards to restraint and seclusion. Utah had some things in terms of restraint, nothing in terms of seclusion, but what they had was minimal at that point. They also, at that point in time, we're talking about 10 years ago, corporal punishment was still an option in schools. And what I'm referring to there is basically you can hit my kid at school as a discipline. It was allowed if parents gave permission. Now, if you tell people that today, like I'm telling you, most people roll their eyes and are shocked that that was okay up until just last year. And that goes across the board in the school settings as well as with parents. As we worked on this in the legislature, school districts came to us and says, this is a real thing, because it just nobody uses corporal punishment in schools. It's such a liability to schools, and of course parents don't want their children hit in schools. So she was looking at that as well. The National Disability Rights Network, it's also known as NDRN, which is the umbrella agency for the protection and advocacy units across the states, also did a 3-part series of reports called Schools Not Supposed to Hurt, where they were sharing actual incidents that occurred across the states in terms of restraint and seclusion in schools. This was very troubling to a lot of people, kind of a shock the conscience experience. So these 2 reports started to bring out the question, do we go to federal law with this, or do the states handle this themselves? Thankfully, what has happened across the states is every state has picked up the issue and decided to address it. And I'm pleased to say that in the last year, we've had some major strides in the state of Utah regarding restraint and seclusion in Utah schools. So many of you might know Carol Anderson. She's over at the Utah State Board of Education. She really pushed for a review of what's known as LRBI, the Least Restrictive Behavioral Interventions Manual, about the same time all of these studies were going on. This manual at the time was only for students in special education. Carol had a great deal of vision and foresight on this and recognized the importance of making this for all students, because frankly, every student in a school setting is a part of that community. And so if we kind of streamline the way we interact with behavior across all students, then really it's in the best interest of everyone. So what essentially LRBI is it's research-based interventions and ways of approaching behavior, both on a school-wide level as well as down through an individual student. And that's why it's got the pyramid on there. It's kind of that concept of the whole to the parts. They've been proven successful in terms of behavior systems and support. The idea is preventative and proactive. And I think that's really key, because one thing I have found, not so much now, but when I initially started in some of this work about 10 years ago, is often the behavior intervention plans would list restraint and seclusion as an intervention. And frankly, what I found is that it really didn't work as an intervention. It usually escalated the student and just made things worse. And so we had a lot of conversations, both parents, educators, all sorts of constituents, on what really is restraint and seclusion. And what we found or agreed to is that it really boils down to being an emergency safety intervention. It's not something that's going to generally lead to positive behaviors, and that's what we really want for students. So we tried to kind of reframe that language so that people understood that really these are ways of just resolving an emergency issue. So just this last legislative session, with a lot of collaborative effort through several different private agencies, as well as the state board, districts and charter schools, there was a lot of support for changing Utah Code 53A11802. This is the code that allowed corporal punishment. The legislature was very supportive of completely eliminating corporal punishment in Utah schools, which we were thrilled to see. There also was some questions about physical restraint in schools. At the time that we changed some of the code, well, the legislature changed some of the code, there were questions about protection for property. So essentially, the state law said you can use physical restraint in school if we're trying to get a weapon from a student, if we're trying to protect them from harming self or others, or they're violent. And then it just said to protect property. The problem that individuals and groups were having with that is property can be a lot of things. It could be a pencil. So essentially, if you read that black and white, you could say we can use physical restraint if a student is breaking his pencil. And that just did not sit well with anybody. So we had lots of discussion about this, and as of May 9th of this year, the rule has been changed to say exactly what it states here. And essentially, if you look at this, what it gets at is physical restraint is used when we're going to harm ourselves or we're going to harm somebody else. I mean, if you look at every single one of those, that's probably going to happen. If a student is violent, flailing their arms, hitting, scratching, so forth, we probably need to do something more than do a physical escort to another place, depending on the severity. But there needs to be limitations on it. So this was the change to the state code. I do want you to notice in looking at this that the code, again, does not state anything about seclusion. There is obligations and rights for the schools to make discipline plans and emergency safety interventions at this time that do outline seclusion, but the state did not, in terms of the legislature, feel a need to address the seclusion piece. They felt it was more appropriate for that to be done on the local and administrative level. So so good changes in terms of the law as of this year. Really, when you look at this, it's not just protecting the students, it's protecting educators as well. It's really best for everyone. So this brings some protections all the way across the board. So then whenever the state legislature develops a rule or a code, part of the code, the state law, then after that, we head down to the State Board of Education, who then interprets that and creates what we call regulations. And the State Board rule or regulation, as we know it, as R277609, is specifically lists physical restraint. It's a little bit different in the definition than what we have on. It's not different. It's just different choices in words than the code. But it basically states that it is terminated when a student is no longer an immediate danger to self or others, or the student is in distress. So essentially, once the student is calmed, we stop the physical restraint. It needs to be used for the minimum time necessary to ensure safety. So that's an argument in terms of what you as a parent may feel versus what a school may feel. This is where actual reports from the school about incidents are very important to understanding. So just so that you are aware, if your student has physical restraint has been used because there's concern about danger to self or others, or for any other purpose for that matter, there should be an incident report that outlines what exactly happened. So there should be immediate notification to parents and administration. So let's just do a hypothetical. We're in a general ed classroom. Some kid pulls out, I mean, I'm doing the extreme here, pulls out his pocket knife. Okay, that's a weapon, right? We're going to use physical restraint, or we're going to call in a school resource officer, whatever we need to do in that regard. But let's just say that the teacher uses physical restraint to hold that student. Immediately, someone in the room needs to go and let the administration know, and the administration needs to let the parents know what's occurring in these situations. Again, we're talking about emergencies. So physical restraint shouldn't be used just when we're having a bad day. We're talking about violence, physical harm to self or others. Physical restraint should not be longer than 30 minutes. That's the law. The law, the regulation states not longer than 30 minutes, and not for discipline. I'm going to hold you until you calm down. I mean, if you can say that, you should be, you're probably not in an emergency situation. I will come to the questions at the end, just so you know, but thank you for asking that question. Seclusionary timeout. Again, it's a safe enclosed area that meets fire and public safety requirements, which we already kind of explained in the definition previously. And it's to isolate from adults and peers. A student is prevented from leaving or reasonably believes they're prevented from leaving. Again, there were a lot of conversations about this in particular because, I mean, people think seclusion is just an area that is set up for just that, seclusion. It can be a lot of different things, and there was a lot of concern about not meeting fire code or public safety requirements. So essentially what they're saying with that is that if you're putting a kid in a closet, that's not meeting the safety instructions that the rule requires. And then, of course, we feel that we can't leave. That's what the students understand. So the rule in R277609 states that it's a minimum to ensure safety. That's the purpose. The door remains unlocked. We've had a few cases come through the DLC where a student is locked in a room. That is not appropriate. The student needs to be in the line of sight of staff. So if they're in a room that doesn't have any windows, again, we are breaking a regulation that the Utah State Board has created. So there needs to be a window being able to see the student. And to me, this is for obvious reasons. Again, we don't use seclusion unless we're in an emergency situation. So the student is out of control and needs a place to calm down. That's the idea. It's not a place to escalate. So we need to be able to keep watching them. We need to be aware. This part of the rule says immediately notify the parent, guardian, and administration. I believe the other says that as well. To answer your question, how soon should the parent be notified? It's not very specific in terms of restraint on the rule, but I would say within a reasonable amount of time, within an hour. The seclusionary part states that you need to contact immediately. So we've had some districts and schools that state we'll get you information at the end of the day or something of that nature. That's troubling to me personally, and I will say the main reason it's troubling to me is because if this is really an emergency and that's the only time we're using this, then as a parent, I want to know. My child's in distress. I want to know. So I think as districts and schools, it would be good to look at how you're using it and make sure that you're using it appropriately and not inappropriately. Okay, of note, sending a student home is considered a suspension. The only reason I'm bringing this up, we've had a few places that say, okay, seclusion says that I can only keep a child in seclusion for 30 minutes. But what happens if the student is still just completely out of control? Well, the concept and idea is you put the student in seclusion, you then have contacted the parent, you've had a conversation with the parent. Now the parent may decide to come to the school, or maybe you're going to have the parent talk to the student on the phone while they're to help calm them down, or whatever the nature of it may be. Sometimes parents have come to the school when seclusion is being used. All of those are great. There's nothing wrong with any of that. But some locations have decided to say, oh, well, once we hit 30 minutes, we have to take them out of seclusion, and we can't handle them because they're having a meltdown, so we're just going to send them home with the parent. Well, that is a choice the school can make, but all case law that I've ever read says if you're sending a student home as a choice of the LEA or the school, it's a suspension. So it should be treated as such. I also would say, just from a practical point of view, that that's really not helping the student, because suspension doesn't work like it used to back in the day. A lot of kids actually think, cool, I get to go home with mom and dad and I get to enjoy the day. So it really does not help. And so what really makes a lot more sense is, okay, we're in seclusion for a period of time. We're contacting parents. Maybe the parent comes to the school or is talking over the phone. We're trying to de-escalate. We come out of timeout or seclusionary timeout. Maybe we just can't get in control. Can I go back? Of course you can go back, but you need to give them the opportunity to come out and get under control, because frankly, everything I have read in terms of research and even in my own personal experience with cases, kids do not settle down generally in an isolation type environment, especially with certain disabilities. Okay, so help. This is happening to my child. I think the first question is this a one-time or recurring event? If you are a parent who has had this happen once, I would be going in and talking to the school administration. Now, when I say school administration, the first line of defense is the principal, assistant principal at the school. So if it's a one-time event, I would be going in and having a conversation with them. My son was restrained here at school. He was being held. There was a fight going on between him and another student, whatever the circumstances may be. I would then have a conversation with them. I'd like a copy of what happened, the incident reports, the individuals who were around during this, who observed it. Usually if it's older students, they may ask them to write a report. That depends completely on the LEA, and there are some questions about getting those reports. But from principals, teachers, and so forth, you can usually get the incident report. I would also really try to be preventative, and what I mean by that is I would be talking to them about, well, what can we do to prevent this happening in the future? This is a really bad thing. I understand that it had to happen, but how can we make this avoidable in the future? All students can have what's known as a behavior intervention plan. That doesn't necessarily mean, a one-time incident doesn't necessarily mean that they need a behavior intervention plan, but you certainly could have some conversations about some interventions that could be had to avoid this in the future. If this is a recurring event, so it's happened 2, 3, 4 times, whether it's restraint or seclusion, again, constant conversation with school administration is important. But knowing what I know from the work I do, there does come a point where that relationship becomes a bit of a challenge, or maybe it's just not working in terms of working together. If you're in a school that's a district school, the next step would be talk to some of the district administration regarding your concerns. If it's a charter school, I would suggest the board, the charter school board, because they're under a different style method than the districts are. I'd make sure that you talk to everyone that you can to try to work through the issues, because really what's in the best interest of the student is to stay in school and to work together to try to resolve that. That being said, you also have the right to provide the school with your interpretation of what happened, and I would suggest that if it's in writing is always the best. So I read through these incident reports, I talked to my daughter about what happened, and this is what I understand to have happened, and provide that to the administration so they have your perspective on what occurred as well. It's very important for that to be in writing. Not only because it just gives documentation, but also because it provides you an opportunity as a parent to really think through your concerns and your child's concerns so that you have a good grasp on what's going on. District and school board involvement. R277609, that's the board rule that talks about restraint and seclusion, requires every school district or charter school to have an emergency safety intervention committee. So if you experience something like this and you're troubled by what's happening, I would go to your principal, like I said, I'd go to the district, and I would ask them, I'd like to bring this forward to the Emergency Safety Intervention Committee. Now, I'm going to be honest with you. Some people are going to say, we have that. Great. We'll let you talk to that group, and we'll let you come forward and tell them your concerns. Others are going to say, huh? Because this is very new. This just came out a year ago. And so there's a lot of districts and charter schools who do not know or just aren't as aware yet that this is a requirement of this rule. So you might be educating them as a parent if you're concerned. So this is definitely something to be used. And what this essentially is it's a group of administrators. I believe it's an administrator, a teacher, a parent, and they look at any time there is an incident of restraint and seclusion in schools. And if you as a parent want to have that committee look at that and look into it further, that would be a real good resource for you to use. Again, like I talked about earlier, preventative and alternative plans are always a help. The use of outside resources for help. Now, I put down the Utah Parent Center. They're awesome for information referral. If you just want to talk through maybe the way to approach this, they might have some really great suggestions, because I know all of their consultants are parents with students with disabilities. The DLC also does this work, so if you were to call us, one thing I try to tell parents is we don't take every call that comes through as a case. So we have a lot of people who just call us and say, this is what's going on. I'm not entirely sure the best way to approach this for my child. I don't want to get into some sort of legal battle. I just want to do what's best. We'll be happy to talk you through some options and things that are available to you. If it's something you're feeling like, look, I've done everything I can do, and I'm feeling like pulling my hair out about this because nobody's listening to me, then it may be something that we help you with some further assistance at the DLC. And again, both of those resources are resources that are at no cost. So just be aware that there are people outside of the school setting that can be of help to you. You're also welcome to contact the Utah State Board of Education with questions. They can provide some technical assistance. But keep in mind that these rules don't just apply to students with disabilities. So when we talk about this, we're talking about all students, and just the use of restraint and seclusion in an appropriate way. I think there's still a lot of work to be done on this in particular. I think that's all I have. So let's go ahead and take a few questions. How does this apply to notifying the parents and the length of time when this happens in foster care? Okay, so I'm gonna go back just for a minute over the notifying of parents. The way the rule is written in seclusion is immediately. In fact, let's just go back really quick to restraint to make sure I'm giving you the right information. It is also immediate in physical restraint. So that means they should be contacted by phone, or some effort is made to contact them, but no longer than 30 minutes. When this happens in foster care, that's a good question. I think in terms of the rule, what we're referring to would be the foster care parent at that point. It does say parent, and I know in special ed law that gets really confusing between foster care and the parent. But I think what we're talking about here, my interpretation is whoever the child is living with is the person we're notifying. So I don't think that foster care would change that. I think it would remain the same. Okay, so another question. Staff has been scratching during restraint. What does the student have when this occurs? So the staff has been scratched and the student. Okay, so if staff is hurt so let's say a staff is restraining a student and they get hurt, the staff does have the right to file a police report on the student. They have every right to do that, and that's their choice to do, or incident reports within the school regarding that. What's the rights of the student? Well, the rights of the student are still the same under this rule. They shouldn't be restrained or secluded for more than the 30 minutes. That being said, I don't want this to sound like the school is just like, oh, it's been 30 minutes, we can take our hands off. If this student is still extremely violent, out of control, we may need to consider the alternatives. And this is when sometimes law enforcement gets brought in. It's not a happy thought. I hate to think of that happening, and I don't think generally that schools, parents, anybody wants that. But there are times when it gets to a point that that's necessary. The laws that govern school resource officers or officers outside of the school that are brought in are not the same as the rules that are required by school districts and charter schools that we're talking about. They are exempted from these rules. So that is a new and a different concept or different set of rules. Okay, we're getting lots of questions, so let's Okay, if seclusionary timeout is being used consistently, what are the options? So this comes up a lot in the IEP context. There are a few exceptions in this rule that you might want to look at in terms of that. That being said, I would strongly suggest that your team look at the LRBI handbook. There are loads of interventions that are available there as alternatives to seclusionary timeout. And the way it's written into LRBI is that you do everything else before you go to seclusion. So my best suggestion would be to have a really good conversation in places where this is happening consistently about what other options they could consider as ways to teach appropriate behavior, help the students to become more integrated into the class setting. Because frankly, sitting in seclusion, it's a denial of a free, appropriate public education if it's being done consistently. Let's see, there was another question, I think. Is a door being locked by a teacher the same as a door being locked? Oh, a door being blocked. Well, let's look at kind of the way the rule is written. Arguably, you could argue yes, that it is. But that is preventing a student from leaving. So the rule would be if the teacher's blocking it, then it could only be for 30 minutes. But I think a teacher blocking it, the difference I see with that is you can lock a door and you can walk away. That's I think part of where it's going. That being said, we don't want a student to be stuck just because a teacher's there. So I think that's a legal argument, Lacey. I think the reality of it is that we'd have to look at the circumstances and see what was going on and if it was appropriate or not. Okay, parent asked several times a week is being asked to come in to be with the student, thus jeopardizing the parent's employment. Oh, that's a good question. Yes, we've had a lot of parents who don't like the idea of you keep calling me and you keep asking me to come in. Keep in mind that this notice says notify. It doesn't say parent has to come in. That's not what it says. That being said, if you've got a student who's being in seclusion and we're contacting parent and then parent comes over, again, I think your team needs to rethink that. And what I mean by that is, why is the student doing what they're doing? Why are they doing it to go to seclusion? Well, because then you're going to call mom and then I'm going to go home. Or then you're going to call mom and I'm going to get the comfort that I need. It's not so much a liability on the school district, the parent's employment. That's between the parent and their employer. But the bottom line is, instead of just continually calling the parent and going through that continual repeated approach, a better approach would be to sit down as a team, whether that's an IEP team, a 504 team, or just a school team of individuals who are working with this student, and coming up with some alternative ways to address the behavior. Because there's always a reason a student does what they do. And so if the student is blowing up every day and emotionally just screaming and hollering, maybe we've got a student with severe autism who's really having a hard time, what other options can we have? What can we do to help the student communicate their needs so that we're not just saying, let's go to seclusion? Parents could be really upset that this is jeopardizing their employment, but the bottom line is, if you are taking a kid out of class to set them in a room for hours on end, you're not providing them an education. And frankly, educators aren't there to babysit kids either. So parents and teachers need to work together to figure out some way to make this work. Yes, a blocked door definitely gives the child the idea that they're not able to leave, and that's a really important point to make. I mean, if you're talking about seclusionary timeout, like we're talking about, the door may be unlocked, but they're blocked, and then you do fall into that category of they don't think they can leave. So then the 30-minute rule falls into play immediately because they believe they're prevented from leaving. Absolutely. You guys have great questions. Are there differences in rules for private schools? Really great question. Private schools are not covered by these rules. So just keep that in mind. A private school does not have to follow the rules that are created by the State Board of Education or even the state law because they are not federally funded. So a private school can choose to do whatever methodology they would like to, which is kind of scary. Are there any other questions? Okay. Well, I would just like to finish up with just a few things just to kind of finish here. I will tell you, like I said, I think this is a huge time, or I will get to that question in just a second. This is a huge mind shift for people. And I think it's a huge mind shift for parents as well as educators. We need to rethink the way we work with students. It's not you're disruptive, we're just going to put you in another room. It's trying to rethink how we help students to stay in the classroom and to learn instead. There was one before this from Canyons. Does the DLC have a sheet on this to share with parents? At this point, we do not, but I will definitely let you know if that's something that we decide to have. We'll definitely be happy to give you a copy.
And I will add to this that as part of our IOTI funding that we have here at the Utah Parent Center, we are going to be developing additional materials on this topic in particular. So we are going to be developing some additional handouts as well as some videos for parents on LRBI and the manual and on seclusion and restraint. So you will see some additional handouts rolling out throughout this school year. And as soon as those come out, they will go through our Utah Parent Center listserv. So you will see some handouts and tip sheets and videos rolling out this school year. So look for those. We are excited to be able to offer those because we realize that this is a big need in our state and that there hasn't been a whole lot for parents to access in the past, and we're hoping that this will really help parents to have more information. So be on the lookout for that.
Okay, so my understanding is seclusion can even mean when a student is removed from the classroom to a smaller room with only a desk. If the teacher's in the room but ignoring the student refusing to talk, is that seclusionary timeout? Well, again, let's go back to the definition that's on the screen right now. Safe and closed area that meets fire and public safety requirements, is purposely isolated from adults and peers. Student is prevented from leaving or reason believes they are prevented from leaving. In your example, as you've outlined, if that student believes they are unable to leave, arguably it could be considered a seclusionary situation. So you do need to keep that in mind. Can restraint be used to bring a child back into school that has left the grounds? Well, coming back to the rule again, just, whoa. Oh, there we go. Thank you. Okay, so let's just look at that again. If we look at the reasons for physical restraint, obtain a weapon or other dangerous object, protect a student or other individual from physical injury. Well, I think if a student is taking off and leaving school grounds, arguably there could be physical injury to that student, especially from an elementary school level. When I taught school, I had a student who would run, and frankly, there was no other way than to either try to do the physical escort, which is what we kind of talked about earlier, which is grabbing the arms and trying to guide him back. But then when he started kicking me in the shin, I, of course, am now being physically hurt, so then I would restrain him. So restraint can be used to bring a child back to school if it's going to be protecting the student or other individuals from physical harm. That doesn't mean every time a student is going off the school grounds that that's an appropriate approach. I mean, we really need to look. If I go over and I take that student's hand and say, no, we're coming back, and they come back with me, that's a much better approach to it than me picking them up and carrying them into the school. So you have to look at the specific child or student's reaction to that. Emergency safety interventions should not be planned interventions for specific students under foreseeable circumstances. Thank you for sharing this. The use of emergency safety intervention should not be included in the student's IEP or behavior intervention. However, an IEP team decides to include the use of in an IEP or BIP, IEP, BIP, or FBA must be conducted and the parent consent must be obtained. If these are considered emergency safety interventions, what are the potential advantages to including it in a BIP or an IEP? Is it necessary or beneficial to include them in a plan? Oh, that's a really big question. Well, first of all, again, part of this is a philosophy, okay, in terms of using restraint and seclusion. There are people out there that would say, and I'm not here to argue with them right now. I may at other times, but there are people out there who say we don't know what else to do, or we don't have any other option. We need to be able to use seclusion. The student's disability is so severe, we don't know what else to do. And that's, I think, why it's so important for your IEP team to have that discussion. Because frankly, and that's the way it's written in LRBI, because it's the team makes that decision. I would definitely make sure you're doing a functional behavior assessment before ever even considering anything, any of these emergency safety interventions. Because again, behavior always has a function. There's always an intent behind the behavior. And those with the most significant disabilities, hands down, they're trying to communicate something and they don't know how else to do it. And so if we're talking about that, and a team feels that maybe this needs to be part of an IEP or a behavior plan, then they better have a pretty intense conversation and have some pretty good data to back that up. And that's where your functional behavior assessments, outside behavior assessments become critical to whatever is decided. Generally speaking, my own personal opinion is I don't like having them in the IEP or BIP, and the main reason I don't is because that document is following a student wherever they go. And often when people see a document that lists restraint and seclusion, we tend to panic and we tend to go there first rather than last. So if we have a behavior plan that says use restraint and the student's out of control, well, that's true for all students. Use restraint if the student's out of the control for all students. Why don't we have some preventative behavior interventions, and behavior interventions like, well, there's all sorts of them in the LRBI. I can't think of anything right off the top of my head, but
take a break.
Take a break, or there's the step one where they go through and you repeat back to the teacher what's expected of them. There's lots of different ones in there. That's what a behavior intervention plan and an IEP should be doing, is helping the student to learn appropriate behavior rather than finding something to deal with when we can't, the consequence when we can't do anything else. So yes, LRBI does list that that's an option on the IEP or BIP, but as a parent, I would say very strongly that you are a member of that team, and if you're not comfortable with that, I'd be very clear about that. Yeah. Yeah, and that's exactly right. The putting the emergency safety interventions first rather than last. And again, that came up in a lot of our discussion when they were redoing the LRBI Technical Assistance Manual. Is the reality of it is, as soon as it's written into the document, it becomes that's first instead of last. So again, if you're a parent whose team is strongly pushing this, keep in mind you're a member of the team and you have every right to provide your thoughts on it and information to them, because they need to know. They need to know where you're at, and your rights matter. And so that's definitely an important point to make, that I would very rarely do that unless there's a full agreement of the team. How long after the child is diagnosed with a disability should IEP be put in place? Okay, so this is a very kind of a different question. diagnosis and classification in a school setting are two different things. So if you're talking about a doctor diagnosing a child with a disability, that's different than classifying a student in a school setting with a disability. So if your child is diagnosed with a disability and you go to the school and you let them know that, and you think your child needs special education services, the school needs to provide you with a form to sign to go through the process of evaluating that student for special ed. After you've signed consent, the school has to complete that evaluation in 45 school days. And then after that, it should be a reasonable amount of time to get that IEP developed. Are there repercussions? Oh, that's okay. Are there repercussions for schools not following or breaking their rules? Yes and yes. Right now, the way the rule is currently written, if a school district, for example, let's say a group of parents was concerned that a school district or charter school was not following the rules outlined in R277-609, they could go to the State Board of Education, the Utah State Board of Education, and request an investigation. So that is a more systemic approach that could be done. If there is an individual child who the rules are being broken on, and then that becomes a legal discussion. So it could be as not easy. It could be a first step of just going to the superintendent, explaining that the rules have been broken, and having the actual district conduct an investigation to address that. Or it could be that you come to a private attorney or to the Disability Law Center and we file a complaint with you regarding these specific rules being broken. So there are options and repercussions when these things happen. I would prefer, and I think everybody, including the parents, would prefer to avoid those repercussions if we can by trying to address these things. But that being said, there are legal ways to address these issues as they come up, yes. Okay. Well, I think if we have all the questions done, you are welcome to contact me directly at the Disability Law Center. I didn't put my email address on there. The phone number is there. You're welcome to call. My email address, though, just in case you do want to contact me directly, I forgot to put it on there, is L. Gillespie, which is, I guess I can just type it in, L. Gillespie at disabilitylawcenter.org. So you're welcome to contact me there as well, even if you just have questions or need to discuss something specific, and I would be happy to be of help in any way that I can.
Thank you, LauraLee. That was excellent. As always, if you do have questions, you're welcome to call the Utah Parent Center as well. We do quite often work with families on issues related to seclusion and restraint, and other questions regarding behavior concerns that parents have with students in their school. Just so you know, we do have a range of services we can offer parents in this area. That range includes one-on-one consultations, so that's where we talk to you over the phone or even in person about your individual circumstances and then kind of help direct you on where to go. We also have a lot of info sheets and recorded webinars, workshops, and a lot of other information we can get you on a variety of different behavior topics. And as I said earlier, we're in the process of developing some additional resources specific to this area. And then we have some higher level supports kind of on an as-needed basis where we can do things like go to IEP meetings with parents as a parent support person if you're experiencing a high level of conflict with your IEP team. And we also have some district consultants that work specifically with certain school districts. So we do have different supports here at our center, and our goal is to help parents resolve disputes on the lowest level possible so that you can move forward with your child and your school team to resolve concerns that you may have. So we are available Monday through Friday, 9 o'clock to 5 p.m. So feel free to give us a call or email us as well. Just like the Disability Law Center, you know, our focus really is to help parents resolve concerns so that you don't have to go to the highest level possible to resolve those concerns. And we do believe strongly that Behavior concerns are really important, and they're one of the biggest areas we get calls for at our center. So it's a very real thing for all of us here in the state of Utah, and it certainly takes a team approach to work through these issues. Unfortunately, there's not easy answers when it comes to these types of concerns, and so that's why a lot of times we really need to do those individual intakes with people, because these are complex issues. And so it's often helpful for us to talk to you individually about what your individual student is going through. All of our services are free, and same thing with the DLC. So don't hesitate to call either one of our centers, and we're happy to work with you individually to assess how we can best support you in your situation, and what types of individual services or supports you may need. So thank you so much for joining us today. We look forward to offering you some additional webinars in the future. And this session will be posted on our website shortly, so please look for that. And we hope that you've gotten something of value today, and thank you so much for joining us.